I'm James O'Donnell with the University of Maryland Francis King Carey School of Law Mediation Clinic, here to talk to you a little bit about mediation. Mediation is an informal and confidential way for people to work through a disagreement. Mediation is a voluntary process which encourages solutions which work for all parties. In mediation, specially trained neutral mediators assist the parties to help effectively communicate, negotiate, and problem solve so they can discuss difficult issues and develop solutions which work for everyone. Mediation is an alternative to trial. Typically, when you go to trial, you'll stand before a judge where he'll call witnesses, present evidence, and argue your case. The judge will listen to the evidence, the witnesses you call, and the arguments you make. And this can be a very formal process and can be difficult and upsetting. When a judge makes his or her decision, the decision is final and entirely up to them, giving the parties no real opportunity to craft a solution that works for them. But as we all know, disputes can often involve more than just facts and figures. Therefore, a trial can leave people with a sense that the problem hasn't been fully resolved.
Okay, I'm ready to make my ruling. I find in favor of the plaintiff for $5,280 plus post-judgment interest at the legal rate. Next case.
So you've seen what might happen in court in front of a judge, but what does mediation look like? Well, let's take a look.
Well, good afternoon and welcome to Mediation. My name is Zach Schultz. You can call me Zach. I'm going to be your mediator today. And how would you like to be referred to today?
Belinda's fine. Nice to meet you, Zach.
And my name is Sonia. You can call me Sonia.
Okay, great. Well, thank you both for trying mediation. As you know, this is an informal process. It's an open dialogue. So who would like to begin?
Here's some important things that you should know about mediation. Mediation is confidential. What that means is that with few exceptions, the mediator cannot disclose what you say in the mediation to anyone, not even a judge. Also, mediation communications cannot be used in court beyond what is included as the terms of your agreement, if one is reached. Mediation is voluntary. You see, in mediation, you're in control, not a judge. If you want to stop the mediation at any time, and for whatever reason, you're free to do so. Now, since you're in control of the mediation, you decide the outcome. Any agreement you reach will be in your words and on your terms, because mediation provides a unique opportunity for both parties to reach creative and personalized solutions that work for everyone. And because you're not going to court, you can decide when and where to meet, so that works with your schedule. Also, because you're not going to court, it often makes resolving your problem faster and less expensive. Finally, as opposed to going to court and having a judge decide who wins and who loses, in mediation, you're in control of the solution, so that way everyone can win. So far, you've seen what might happen at trial, and what mediation looks like as an alternative. But you still might be wondering, is mediation right for me? Well, let's hear from an experienced trial court judge about why you should try the process.
I would encourage parties to give mediation a try. It's an opportunity for them to use their own voice in expressing what they are seeking as a resolution to their problem, to explain and define what their issue is. It's a chance for them not to be bound by the formal rules of court procedure or the formal rules of evidence. It's a chance for the parties to address any and every issue that is a part of their dispute, even some issues that judges aren't authorized by law to actually preside and resolve. And maybe they can say, you know, this is for me. This is something I'd rather do than to have to air my dirty laundry in front of everybody on the record, having somebody delve into my family business or delve into my finances. Maybe I'd rather do this in a confidential process where I can just work it out. I think sometimes people are hesitant because they're just not familiar and they have that traditional court trial perspective when they're coming into the courtroom. They're not aware that there's another way. And I think if you can get the word out and help people to know that there is another way, a way that can be just as satisfying and maybe even more comprehensive, more effective, more cost efficient, I think people would be willing to try it. There's no downside in my mind. You don't lose any ground by going and talking and participating in mediation. If it doesn't work out, you can still always come to court and a judge can decide your case.
Hopefully, after watching this video, you've gained a better understanding of mediation. But if you have some questions, we here at the University of Maryland Francis King Carey School of Law Mediation Clinic are available to answer those questions, provide you with more information about mediation, and possibly mediate your case for free. If you'd like to contact someone here from the Mediation Clinic, please feel free to call us at 410-706-3295 and ask for the Mediation Clinic, or email us at cedrum@law.umaryland.edu. On behalf of everyone here at the Mediation Clinic, thank you for taking the time to watch this video, and we look forward to possibly helping you in the future.